Recording in progress.
Hello, everybody. It's 10 o'clock, so it is. Apologies, please. Welcome all.
Morning, Chair. We have one apology from Mr. Dedoit.
Right. Nobody else, right? So, right. Okay. Let's go for it. I think we all know that whether people appear physically here for an oral hearing or they send a written submission is the same status. And when they're not here, we usually get a summary of their issues. And I think that's normally done by the staff. But I think there's been some, I've just noticed this morning, it's too late, there was no overview done by the research unit. But anyway, it's fine. Maybe I should have reminded them yesterday or so. But please, in future, the responsibility to do an overview doesn't reside with Treasury alone. When there are submissions that have come to us, we don't always do it, but I was thinking about it this morning. Let's institutionalize it. It's been there, but now and then we slip up. Because Treasury does it, the executive shouldn't be doing it. They can do it for themselves. It's their response. We, Parliament, our research unit and content advisor should do it, please. I accept that I should have reminded them, but it didn't occur to me. I read the submissions this morning and realized, of course, there's no summary of it by Parliament. So please, can we do that in future? There's several bills coming. Let's avoid that. When it's oral submission, people are here, so we hear them. So fine, we can't jump into your response, Treasury. We must first get an overview. So can you take us quickly through? There's some things I'm not sure that I fully understood, but I think I got the basic thrust. So can we start, please, on your side? Can you take us through the first one that came to us, and then the Free Market Foundation? Okay, so who's leading the team on your side, Treasury?
Good morning, everyone.
Yes, of course.
It's Wendy Fanner from National Treasury, and I'm leading the delegation. I'm joined here with Sandra Secretary, as well as also my trainee, Mapiano. And we will be doing a joint presentation. And what we've tried to do is to take, if you can put the presentation on the screen so long, I'll appreciate it. What we've done is we've summarized the issues that's been put forward by both institutions, and then we've analyzed and
I saw that, yeah, but we're interested in your response. First, we want to hear what they said from your point of view, and then maybe those who are more familiar with this thinking and identify with it might want to add, and we'll come to your responses after that. So Dennis might want to add, and Mr. Dutoy is not here, and whoever else wants to add. So let's go for it. First, what exactly has Cape Town said? Colleagues, you've got the submission that Nkululeko sent it to you late last week. Right, go for it.
Okay, we'll first just take you through, but our presentation also covers what both submissions have said.
But let's start with them. I think it's correct to do it like that. I know the way you do it. That's the executive. We take responsibility. I, in particular, I should have reminded the staff that they must prepare a summary because we need a summary from them. In other committees, the staff actually do an overview, but in our committee, for some reason that befuddles me, it doesn't happen. Okay, but I don't want to go there. Right. So that's a problem for the new chairperson. Right. Go for it.
Sandra, I see you the co-host. Can you just put the slide presentation on, please? Sandra, if you're struggling, can we ask the committee the secretary to do so? Okay, there we go. Okay, can we go to the, we're first going to start with the City of Cape Town. If we can go to the third slide, please. And what we'll do is we'll just focus on the first left-hand column where we try to summarize the inputs that we've received. And maybe just to highlight what the City of Cape Town also indicated in the letter that we did not add here is that we've had extensive consultations with all metros and with Salga and the like, where we've had even long sessions in Pretoria where we've had
I got that sense. Yeah.
So they did indicate, that they had a long list of issues, but now they've got a short list of issues because they did see that we've accommodated a lot of their concerns, and that they've just got a few more issues to raise. So it's important to stress that point. And then the first one that they've indicated is that they welcome the definition on bulk engineering services, but then they want to have clarity and guidance on the process and how it aligns to the spatial development frameworks. So what is quite clear here is that they're happy with the definition. But they need, just guidance and clarity. The second one has got to do with internal engineering services, and that they propose that the wording be changed. Instead of using engineering services, that they propose that we use the word municipal engineering services. The reason why they've requested that it does not necessarily cover the case where a private homeowners association is responsible for engineering services within the boundary of the common property. So that is an issue that they've raised, is that the addition of municipal engineering services be added. If we can then go to the next slide. And then the issue is raised about, and it is quite a complicated issue, this about engineering services. Is in certain cases when you use the terminology internal engineering service, it does not consider cases where bulk and link engineering services are part of internal engineering services. And maybe to give an example, for example, if you've got a road that goes through an area, it can be bulk, but it can also be, going through an estate. Then it becomes, internal, and so there could be confusion. In certain cases, also bulk goes through a property where it's owned by an individual. With it's actually a bulk and not internal, although if a bulk generally or internal is if it's in part of a proper owner of a property, then it will be seen as internal. But if it's just for example big water pipe going through that property, it's actually bulk. So it's things like that where it can become quite complicated, and so that point is just made. Next slide. Then there's also an issue raised that there's a need to look at the relationship of the applicant referred to in Spluma, who is not necessarily the landowner, and the owner of that's used in the Municipal Fiscal Powers and Functions Act. Next slide. Sandra will continue with the next 3 slides, and then Matweni will take you through the last 3. Thank you. Sandra, over to you. And don't forget to show yourself.
Thanks, Wendy. I'm the one who's going to take you through this part of the presentation, and then Sandra will do the last part of the presentation. So they've raised another issue relating to engineering services agreement. They were suggesting that the whole section that deals with engineering services agreement should be inserted into Spluma. So basically, they want us to remove section 9F and put it into Spluma, given that section 49 of Spluma refers to the provision of engineering services, and this requirement will be imposed through the planning legislation. And they also suggested that subclause B should be removed from the bill, as the city cannot contractually commit to future repayments to developers, as it might not be in line with their budget process and budget provisions. Next slide, please, Sandra. And they are also indicating that under Section 9G, which deals with the provision of external engineering services by landowner, the city is of the view that this clause would in practice commit them or commit their budget prioritization in areas which are not necessarily a priority in terms of the IDP. So they are also suggesting a way in which this section can be amended under subsection 4 by just indicating that the municipality may reimburse or offset the amount in excess of the development charges, provided that that forms part of the municipality's master planning and capital budget prioritization. Next slide, please. The city is also of the view that the bill does not cater for a scenario where an applicant is responsible for the installation of bulk engineering service if a land development requires the installation of this bulk engineering services, but if the land development requires the installation of the bulk engineering service other than in accordance with the applicable service master plan or capital budget of the city, if the city in the conditions of approval requires the applicant to install such a bulk engineering service. Next slide, please. Sandra, you can take the committee through the rest of this presentation. Thanks.
Yes. Thank you, Machini. So I'll take you through the next two slides about the submission from the Free Market Foundation. If you look at the document that is submitted by the Free Market Foundation, there are 21 points in the document. However, some of the points are not necessarily comments to be responded to. They are just background. So we have summarized comments from 9 to 12, where the Free FMF is of the view that regulating the engineering services, such as municipal roads, solid waste disposal, electrical street lighting, water, stormwater drainage, and gas, encroaches unconstitutionally on areas of exclusive provincial legislative competence or matters of concurrent provincial competence. But our response is that Schedules 4B and 5B of the Constitution are not applicable as it relates to
we
this
don't want
law.
to hear a response right now. We want to hear what they say and then let the members add if they want to, because those people are not here, right, as I explained. And they must be given a fair hearing. Okay, if you don't mind. You know, if they made a submission orally and we've heard them, then it's fine. This is a proper process. Here, they've made submission, especially the Cape Town submission, to me, has some substance. This one I have my own views about, but you know, there are people here who will identify with them and they may want to expand on what's being said. So to be fair, my friend, can we just stick to the procedure? Thank you. Which is just give us your overview of what they said. That's all we want. And then we will hear from the members if they want to add anything. Should they not want to add anything, you can then just give us your responses. Sorry, are we lost? So just raise the issues on the left column only, please.
Okay. Yeah, so I have already, can you go to your next slide, please? So the next issue or concern that they have raised is that the memorandum of objects to the bill allows the National Assembly to override any amendments made by the National Council of Provinces regarding the bill. They further indicate that this will be contravention of the Constitution and glaring violation of the rule of law. The next concern that, the last concern that there is was that they acknowledges that power of municipalities to impose taxes, levies, and duties may be regulated by national legislation, but caution that such a national legislation should not undermine provincial legislative powers or subvert parliamentary procedures. This is the last slide. Thank you.
Okay. Does anybody else from National Treasury want to add anything? No.
Chairperson, just to check, if you're fine with us going just through the summary, we can also quickly, they raised 20 points, and what we try to do is to summarize it into the key points that they've raised. But if the committee requires us to raise all individual
maybe
20
we can do that. Okay,
we
go
can.
ahead. Yeah. But you know what my point is? You see, sometimes we receive submissions that carry no substance, right? Now, this is an entire metropolitan municipality, right? They have to be taken seriously, whichever party is governing them. And they are the practitioners, right? We're not. So, we have to judge. Firstly, the principle should be that if people don't appear, they must be given the same status as I've been pleading since 1998, okay? That's why we summarize the submissions, even when 500 people have made oral submissions and only 4 have made written, and we look at what they said. Secondly, following a debate we had last week, it struck me again and again that we need to stamp this thing. That, the executive, it's something I've been raising repeatedly. Parliament should not hand over to the executive some of these functions, right? I raised it in a forum, and there was a lot of support for it, as there's been since, I think, 1999, when we came back in the second term. Nothing happens about it. But you know what? I really feel that those who stay on need to look seriously at this issue. So it's not about these 2 submissions alone. It's about the way we function, the way we forego our powers to the executive, really. And this is something new. We never had it like this, my friend. We always had our own staff doing it, and previously we used to hire external staff when Flynn Jinwala allowed it, because it's really a function of the parliament, not the executive. Anyway, for what it's worth, as I exit, I've been asked to do some work on the oversight role of parliament, so many of these issues are also occurring to me for that reason too. But really, you're doing nothing wrong, Treasury. The fault is on Parliament's side, on our side, on the side of the chairperson, starting with me, that we don't do enough to put pressure. We do, but we don't follow it through. So fine, we are where we are. You go for the summary, it's fine. But then there are people here who, it seemed to me last week, would identify with these issues, and therefore they must be given a chance to speak and add and buttress, and then we will look at your responses and take the debate forward, okay? So go ahead, please. Is anybody who disagrees with this process? I'm cool, right? I'm just doing what a chairperson should do, but, people don't have to agree with me. Anybody unhappy with what I'm saying? Nope, go ahead, please. Do you want to go ahead and do that? Hello? Wendy? Is Wendy lost?
No, Chairperson, I'm not lost. We can go through National Treasury responses now if the committee...
No. Sorry, I'm a bit confused. You said you had a summary of all the key points made by the submission in some other format other than what we've got here. Is that true, or misunderstood you? Did I misunderstand you?
No, Chairperson, we presented the summary.
Yeah, I know that, but I thought you had another more pithy, one where you got it all. You see, like this is done in a. I thought, like some of us do with our notes. We will summarize what you've got into like a page. I thought you had that. I often do that. I haven't done it for this. It just makes it easier for me to organize my own thoughts. A lot of us do that in different ways, but fine. Okay, members, what is it that was summarized by Treasury that you feel hasn't covered what they say? I'm particularly interested in City of Cape Town because they're practitioners. On the constitutional matters, obviously, Wendy, we're going to ask you, you got all the right constitutional opinions. If Frank is here, he might want to say something, and so on. Now, I see Dennis's hand is up. Okay, go for it, Dennis.
Yeah, morning, Chairperson. Morning, everybody. Thanks very much. I think the submissions are quite useful. And I note we focus mainly on the Cape Town submission and not so much on the other one. What I'd like to pull out of that submission is something that Treasury has not necessarily focused on. from the Cape Town Metro's perspective, and it falls under the general comments. So I understand why Treasury has responded in the way that they have, and I think I'm not going to critique them too heavily because they're not normally required to give a summary of their opponent's argument. I say opponents in inverted commas, of course, but yes. So I do want to draw everyone's attention to page 2 of the submission, and the second paragraph on that page, which says that while acknowledging and accepting the principle of user pays, prospective micro developers often lack upfront financing, which can impact on the viability of the development. So what they're raising for us here is for me quite a big concern that I hadn't picked up in the first round and certainly in my initial consultations. But what they're saying is that we're kind of reducing the pool of people that can afford to be property developers. And Chair, I think that kind of goes against what this government has been trying to do. I think we've tried to err on the side of inclusivity in the past, and we've tried to lower the thresholds in order to create a more even playing field, and to take out the fact that the same developers that have been developing for the last 50 years are still the ones that are able to continue developing because they've got the financial muscle behind them. And I think that concern is well noted by me, and I don't believe that Treasury has responded properly to it. And it is something that I'm actually very worried about, is the fact that are we in fact making property development a very difficult game to be in, with high barriers to entry, and substantial thresholds for people to get over, which would then of course reduce the ability of municipalities to encourage, first of all, inclusivity, but also a diversity of developments. So, Chair, my history, I was the member of the Mayoral Committee for Engineering Services at Midval when I was there. So I've experienced some of the issues that arise from these bulk contributions that come in, and how it can tend to limit people unless you have a reasonably flexible system by which you can levy these charges, and of course receive payment for them. So again, Chair, I go back to the question that I asked when the bill was first presented to us. I'm not sure why we need this bill. The bulk contributions or development contributions, or whatever you want to call them, are being levied by many municipalities already. There is, within SPLUMA, due mention given to them, and it says that they can be charged. I don't know why we need another bill to repeat what authority has already been given. And again, if that authority has not been given, we're in a very, very dangerous space, because now we've got a lot of municipalities that have been charging this for quite some time, and I hope they haven't been doing it irregularly. So I really want to ask, why is this bill necessary? I asked it last time. I didn't get an adequate response. I got a response that because SPLUMA doesn't say enough. But then how are the other municipalities that are currently doing this doing it? Point is, Chair, if we try and put in a one-size-fits-all approach on this, we are going to close down smaller municipalities, and in fact, we are going to take away the ability of municipalities to govern themselves, to differentiate themselves from their neighbors and their effectively competitors. And it's essentially what we're looking at. And I mean, the Sedibeng Brewery was a case in point. It was almost a competitive bidding process to see who would be able to get Sedibeng breweries to develop in their areas. and it was a case of, yes, certain bulk contributions were beaten around for them, and charged in interesting ways. For example, they developed an entire reservoir at their expense on behalf of the municipality, and then the municipality gave them certain discounts over time as other users of that reservoir came on board and paid bulk contributions. So are we trying to remove the authority from municipalities to be a little bit more agile and flexible and dynamic in terms of the way that they're using bulk contributions to fund themselves? In addition to which, municipalities that find themselves with surplus capacity already may find that they want to give incentives for development to take up that surplus capacity. Are we removing their ability to adequately decide for themselves how they want to charge these things? And that, of course, leads me to the second point, which relates to the tagging of the bill. And I go back to the answers that we had last time, and I see that the Free Market Foundation agrees with me that this really is national government starting to move in on a space that is not necessarily theirs. And realistically, Chair, I think that Section 76 applies far greater than Section 75 in this instance. The fact is that I heard Advocate Jenkins' arguments last time. Well, it's only the financial aspect, but it really isn't, because it removes that ability for municipalities to decide certain things for themselves and to govern themselves. So I hear the test that's applied by the tagging committee. I realize that there is a 3 or a 5 day window for tagging, and perhaps we should have reacted to this before. I am someone who always prefers to err on the side of inclusivity when it comes to public participation. And so, I'm still uncomfortable with the tagging. And yeah, Chair, those are my inputs. Thank you very much.
Anybody else? I see Dikoledi is there. Okay, go for it.
Thank you, Chair. Good morning to everyone on the platform. Chair, I think to a certain extent, Honorable Ryder has covered me, but I have a bit of confusion. Maybe one is not familiar with this or have the same understanding in depth as the Honorable Dennis is. Let me start by appreciating the presentation and also the involvement or the engagement, the extent at which they present they have, and that there were engagement with the metros and SALGA. But I see, according to me, on the presentation, they highlight what was presented by, or the concerns from the city of Cape Town. But I want to believe that in their engagements, the responses from Treasury will include the view of other municipalities and SALGA. Chair, I just want to understand, according to you, I know the stakeholders or the city that have raised this issue of changing internal engineering services to municipal engineering service. What impact will it have? What difference will it be if it is maintained as an internal engineering service than changing it to municipal engineering services? On Section 9F, Chair, the suggestion that this municipal engineering services be included in SPLUMA. I want to speak about SPLUMA. I don't know if Department of Human Settlement as the custodian of Spluma, will it be included in the process, or has it been consulted also at that stage? Or I don't know. I just need clarity on that. What is your understanding as Treasury for one to make an informed contribution? Thank you, Chair.
Moletsane, my friend.
Thank you, Chairperson. Good morning, Chair, and good morning, colleagues. Let me first start by appreciating the presentation. When listening to Honorable Ryder, he spoke about, he was asking whether this bill is not better be in Section 76 than Section 75. I just want to check, Chairperson, because when this bill was presented in NA, the Minister of Finance wrote a letter on the 5th of April to the Standing Committee, making some recommendations of some amendments not to be taken into consideration, not to be approved. I want to check with the Treasury whether those two amendments did they fall off, or what happened after the recommendation, or they were carried as they were recommended to as amendments. Thank you, Chairperson.
Thank you. I would prefer that, but I don't want to impose this. I just think it'd be swifter to process matters, for us to deal firstly with the constitutional issues. Because we don't always recognize that sometimes when we argue, all of us, including me, about what we think is constitutional, in our subconscious at the very least, we're fitting it into our perspectives on what should be the case, or ideological or policy approaches. So, for example, I've never hidden this. Not from a practitioner's point of view, but from a legislature's point of view. From 1994, I was in that sphere of local government, in the policy terrain. I have consistently said that we underestimated the challenges we will have in local government when we shape that model. And as we look around us, colleagues, across all parties in different ways, we're saying the same thing. Municipalities are in excruciating crisis. The Auditor General's reports are a glaring example of that. And there's no sign things are picking up. And then the provincial and national government can't run away from our responsibilities. The truth also is the provincial governments are, in general, less capacitated, so to speak, than ourselves, even though we ourselves at national level lack an enormous amount of capacity. So my own approach is that it's irresponsible for national government not to intervene more within the constitutional constraints. But in time to come, we must review the Constitution, really. If things are not working, we have been arguing for a long time for a review of the powers and functions between districts and locals and between provinces and municipalities. Some of us feel there should be a strong national government and a strong local government. But as a part of that process, we need to, for the time being, have more provincial and national, let's say, support for local government. But of course, you can't challenge the provincial powers and functions because they are powerful forces there, not least in the Western Cape. We'll see it as an ideological attack on them, though the issue would apply even if the ANC controlled all 9 provinces. So as far as that goes, I'm not hiding anything. I feel, yes, there is a need for this bill, not because national government wants to intervene unduly. I mean, I'm one of the people that still vigorously defends the powers and functions, Dennis, whether you want to believe it or not, of local government. But I'm completely of the opposite view of Dennis. I think this bill is long overdue. I don't know why. I was part of that cabinet structure, urban, what were we, IUDF, Integrated Urban Development Framework for 4 years, coordinating on behalf of Cocteau. And many of these issues in different ways emerged then. So I totally disagree with Dennis on that matter. But that's not the issue fully here. Where I entirely agree with him is he's right. Cape Town's drawing attention. It's something that's been niggling me as well, but he's put it much more starkly. I think he's right. Many of these transformative things end up unwittingly, unintendedly, penalizing emerging contractors and entrepreneurs. The same thing happens in the insurance sector and elsewhere. You have to find difficult balances between creating the space for emerging entrepreneurs in the financial sector, protecting clients, not least disadvantaged people who are primarily the losers out, and transformation. It's the same set of balances. There's no easy answer. Each is a case-by-case matter. But I agree with him. I'm really keen to see what you say in reply to Cape Town, raising that matter. Cape Town of all municipalities, interestingly. So, because they're normally accused of not being transformative enough. And I have my own views on that, but I don't want to have a long debate here, right? And then the DA is going to pounce on me. It's not relevant. The point is they're making a good point, was treated on its merits. So I just want, greater clarity on the Section 76. I must say, Wendy, I was a bit surprised, frank, that it's a 75 bill. But I'm no legal expert. I take it the state law advisors approve, that Parliament's lawyers have approved, and the executive's lawyers have approved. But the tagging system, I think, is ultimately processed by Parliament. So in fairness, Frank should come in there. Can I suggest, let's deal with the constitutional / freedom front issues and Dennis's issues about constitutionality, and then look at the policy issues. It'll be easier there because it's easier for us maybe to find some consensus on the need for some amendments. Is that agreeable? But maybe, you don't agree, then we can do it some other way. I don't know. I just think let's just deal with the constitutional issues because we're not experts in it. And finally, if Cape Town or Free Market or the DA wants to take it to court, we should avoid it, but they have a right to do so. And they need to test it because this is part of the approach of the DA generally. So maybe you also go to court. You can use the Cape Town municipality to do it, of course. I'm just saying. So I don't know that we're going to spend hours on that. The more important issues are the other ones raised by Dennis, Tikeledi, and even Moletsane about 75, 76. So if it's okay, can we start with the Treasury dealing with those issues, and let's hear Frank. Ultimately, we go by what Frank says, because he represents Parliament, unless he's obviously wrong. And we are convinced by the lawyers from the executive. Okay, is that all right? Right, people can butt in if they don't agree. Fine, let's go for it quickly. We're wasting too much of time. I'm babbling on.
Thank you so much. If I can please ask Advocate MP van Schoot to come in first to deal with the tagging issue, the 76 versus 75 issue. And then if Advocate Frank Jenkins wants to add, and then I propose we then go to the issues raised by the committee members, and then we can go through the presentation that National Treasury prepared, if that can work best. So Advocate Schoot, first, can we start with you?
Yeah, but she also needs to say that you took the bill to your lawyers or external lawyers to check its constitutionality overall, not just the tagging. There are two aspects: the overall constitutionality around powers and functions, and secondly, the tagging. Thank you.
Good morning, Chairperson, other members of the committee. Yes, we went through the normal process of all our bills. Before we go to cabinet, we obtain a preliminary opinion from the state law advisors, and then also the final version, before it's tabled in Parliament, is scrutinized by the Office of the State Law Advisor, and they expressed the view that the bill is constitutional, and also expressed the view that the bill should be tagged as a 75 bill. At this point, I can't add much more than what Advocate Jenkins said at the previous meeting we had about why it fits with 75 tagging rather than a 76 tagging of the bill. I just want to add something else, that the only change that were made in the National Assembly is there was a reference to of this act that was amended, and then we subsequently, now when the bill was before is before this committee, we requested that 2 amendments. That was in our letter of our minister dated 9 April. So I just thought I should respond to that. Thank you.
Can I just check something? Did you get any submissions from the public, stakeholders and whoever, when you gazetted this bill, that this bill is unconstitutional? And secondly, from what you're saying, am I right to understand nobody raised the constitutionality of this bill on the NA side? Thirdly, did the Freedom Front make a submission or not to the NA?
Chairperson, maybe my colleagues from IGR can assist whether there was a public submission regarding this, but the institution didn't make a submission to the National Assembly on this matter. Thank you.
Wendy, did anybody raise this thing in the hearings on the other side?
Matwini, can you come in here, please? But it wasn't raised, but we can also indicate what we received when we did our consultation processes and whether that issue was raised. Matwini, can I hand over to you on this issue?
Before you go on, just see what's in the chat. Somebody is saying something.
No, Chair, just on a lighter note, you called the Free Market Foundation the Freedom Front Plus, and I'm just indicating they may take our next to them. But
okay,
if I can just use this opportunity to interject and say, I believe that the understanding of tagging of bills on the National Assembly side is probably not as sharp as it is on the NCOP side, because obviously it affects us. Tagging affects us a lot more than it affects the guys in the National Assembly. So I do believe we have a stronger focus, and certainly the people that monitor our house will have a stronger focus on tagging, but that's just an aside.
No, it's not an aside. You're right. You're absolutely right. I don't know why you raise difficult questions about constitutionality of this bill, which I think can't be settled here. But when you're raising a good question in the view of the chairperson, for what it's worth, I'm merely the chairperson, right? That's a very good point. He's absolutely right. I thought about it many times when you've raised it now and then. Not many times now. Well, you raise it now and then, and it struck me myself. By the way, when I looked at it the night before last week, Tuesday, I also thought, hey, what is this bill? By the way, it's nothing to do with ideology, really, from Treasury. And who are you to talk about ideology to me, right? Frankly, right? So, at least I recognize my ideological biases. One day, hopefully, National Treasury will recognize its. So, hey, you know what? He's right. When I looked at the first thing, why is this a 75 bill? Then when I listened to Frank last week, I thought, okay, it's Frank, with due respect, we really value you, at least I do, and I think others do, your commitment and your work ethic and your availability. But, we can agree to disagree. I'm not a lawyer, right? But I wasn't wholly convinced, really, Frank. I said, hey, he knows better. Fine. It looked very odd to me, Wendy, that it was a 75. Right? He's raised it again, and I think he should be given a chance. And you're absolutely right on our side. The truth is also, can I say, Dennis, when I was there on that side, or asked Dick Lady, did we even look at it? Well, I did sometimes, because De Beer was always with me, phoning me and checking and finding out, the chairperson on this side in the previous term. He was a wonderful guy to cooperate with. So I was aware of it, but it wasn't something I felt strongly about. And maybe it's true that any chairs and whips and those who are more active in committees feel, it's better it's 75, then they won't get problems, if you like, from their comrades and members on the other side. And so beside, it's probably true. I am still a bit puzzled, but I accept, Frank, what you said. Okay, so the second thing is, let me drop the second thing. Let's move over to that. Frank, my friend, please.
Good morning, Honourable Chairperson, honourable members and colleagues, also from government departments. Chairperson, I don't want to really start acting like an advocate, having to defend our legal opinion. I've been found wrong in the Constitutional Court as well as other courts on tagging, but we've developed our tagging and the courts have helped us very much with that. So the sort of passive aggressive response is what one will say is, if it must be 76, why must it be 76? But that's not the question. I mean, that's all within the opinion that we wrote about it, and that is in fact how we approach this, Chairperson. There's two really strong court cases that has come forward from the Constitutional Court. Now, one is from the Cape High Court, and the one from Constitutional Court really says that when a bill will deal with matters, and when those matters that it's dealing with in a substantial measure affects one of the items in Schedule 4 or 5, those are schedules to the Constitution that sets out the concurrent legislative competencies of provinces and national. And then there's a section B in Schedule 4 and 5 that deals with local government issues, that in terms of Section 44, national government can intervene under certain circumstances. Now, all that legislation must be 76. So there's various, what we will call now concurrent competencies, functional areas of concurrent competencies. And when we look at Schedule 4, we do see the competency, the regional planning and development. When you're looking at Part B, there's municipal planning. Now, both the state law advisors as well as our office have looked at those competencies to say, does the bill actually regulate that? Now, whereas Tongowane has said there must be a substantial measure, there must be an impact or an effect in a substantial measure on these competencies. And what it means, Chair, is that if a bill is about electricity, for instance, one bill we're dealing with, but the bill goes as far as not just dealing with the national grid, it also deals with the distribution or licensing of distribution at all levels, including local government. Then we have a bill that actually affects in a substantial measure one of those competencies, which is electricity reticulation. Now, in this instance, the question we ask is, does this bill that sets out this preconditions or develops then the competency of local government to levy these charges, does it in any way or in a substantial way affect issues of regional planning, municipal planning, regional development? Or is this just what we call knock-on effect? There was a case in the Western Cape High Court where the court said the substantial measure test in Tongowane doesn't mean that as soon as something affects in any way one of the competencies there, it must be 76. Court said if that is the case, we're going to have most of the bills going through the 76 procedure. So where a bill merely has the effect of knocking on one of those competencies, but not actually regulating it, then there's not a substantial measure test that's being developed or being answered there. So in this specific bill, we felt, reading through the bill, that there's no actual regulation of municipal planning, no actual regulation of regional planning, development. This bill creates the opportunity for local government to levy charges when there is those kind of developments within the area to strengthen their own maintenance as well as the establishment of those services. So we felt that this bill is rather, and let me go back to the first question. There's nothing in the bill that says it must be 76. There's nothing in the bill that says it must go to 76. All bills are 75 until we say, well, this is not really a 75 bill. This one deals with, or in a substantial measure affects, the competency set out in Schedule 4 and 5. Or one of the listed grounds. There are listed grounds that deal with public service and ethics of public service and the public protector issues, which may all be 76 legislation. So, Chair, if I can summarize that, there's nothing in our mind in the bill that says it must be 76, regardless of the fact that it actually enables development at the local government level. It doesn't actually regulate that development to the point where it falls within those concurrent competencies. So, Chair, the discussion around these issues, if I may add this, when we start with, when a bill is introduced and it comes to our office to then advise the joint tagging mechanism on how it should be classified, we pay attention to what the department has indicated. We pay attention to what the state law advisors have indicated. We recently had a bill where the state law advisor says the bill must be 76, and the department says it should be 75. The minister introduced that bill as a 76 bill. However, our office, from where we're standing, feel that it should be a 75 bill. It's not strong enough reason to be a 76 bill. So sometimes there's a difference of opinion. And Chair, when we start now, when we get that bill in, we do distribute it to our colleagues at the National Assembly, as well as the NCOP senior level, who advises the chairperson of the NCOP. We share that the bill is here. We share our preliminary reviews with them, and we ask them to make any input, should they have any, on this legislation. So we try to be very inclusive and consultative when we do this tagging, because a wrong classification of legislation will inevitably lead to a challenge in the Constitutional Court, as what has happened in the past. So we're very aware of those consequences. But up to now, Chair, we haven't had any views on the tagging, except from Mr. Ryder and then yourself, which is the question, and we welcome that. So that's why I started in the beginning. I don't really want to defend the position, but I want to explain how we got to where we got. And of course, one is open to further debating this. I think if we get to a point when we're dealing with this, and it should be 76, then that's the route we should take to prevent any kind of, or to manage at least the risk of going the litigation route and being found that we need to redo the whole process, because that is what it will entail if one gets it wrong. So this is where we are, and we will look at the submissions, Chair, and see what is said there. But it is not a freedom of choice issue. It's a constitutional legal issue. Which route that one or two judgment, that's if you err on the side of caution, you can take it 76 in any of it. But while that has been said, there's been other cases to say if a bill is 75 and you follow the 76 route, it's wrong. It must be 75. So you need to follow the correct route. It's not all just let's err on the side of caution and give provinces a say in this bill. If one allows the provincial legislature to vote with mandates on a 75 bill, it's unconstitutional, and that process will also be wrong. Thank you, Chair.
Thank you. Does anybody else want to come in? Not for now. Okay. Not even Advocate Ryder. No, look, firstly, I want to say this is a more expansive and comprehensive and more formidable input. I don't have the technical capacity to challenge it. And I think, on the tagging, the issue is settled for now. Nothing stops the DA, while the rest of us are focusing on the election campaign, briefing lawyers and all, to take it to court and right up to Constitutional Court it'll help the ANC because then we can focus our energies on the campaign. So having said that, that's not for minuting. In Kulileko, obviously, there's a minute. Okay, Dennis, I'm just needling you. Okay, on the constitutionality of the bill, I really don't have anything further to say. And unless anybody else has anything further to say, I really think we should move on. Okay, fine. Good. Now, let's deal with the issues, Wendy and your team, that we raised. The policy issues by Dikeledi, Dennis, and Malsari raised a tagging issue. Can we please? Oh, yes, and he also raised one other issue, right? Go for it, please. Wendy?
Thank you so much. What I'll start with, and my team will also add, the key issue I think that we first should start with is the issue raised, why is the bill necessary? Why did we just not do it? Reference is made to Spluma that development charges may be levied. That is 100% correct. And the reason why there's just reference to development charges, the understanding that we had between the two departments from inception when the Spluma was done is that National Treasury will do the more detailed regulation thereof, because municipal user charges, municipal taxes and the like should ideally be done by the National Treasury, although it's currently a shared responsibility between National Treasury and the Department of Cooperative Governance. So we've got agreement with the three departments, including DCOC, that National Treasury will take the lead with regard to regulating development charges. What is quite important is what will happen if we don't regulate it? And that's the question that we need to ask. Yes, currently it is not just reference to Spluma that regulates development charges. There's currently 4 provincial ordinances in place that regulates development charges. They were developed by different provincial administrations. They put their own rules and regulations in place. At that stage, we did not have wall-to-wall municipalities, so the provincial ordinance do not cover all the municipalities or all parts of municipalities within those the specific provinces. So it's creating huge confusion out there. What is the friend of confusion? Litigation. So what is currently happening, to put it bluntly, those municipalities that's brave enough to levy development charges, they are often open to litigation. Other municipalities that would want to levy development charges don't do it because they're scared that they will face litigation that will keep them in the courts for long periods of time. So it's created a very unfair playing field where these legal confusions have not complemented the use of development charges. In reality, it's prohibited the use of development charges. So the whole reason why putting in place the legislation is to take away that confusion and to create a more uniform system. The uniform system does not mean it's not got flexibility. It's still got substantial room for flexibility, where firstly a municipality may decide to levy development charges or not. It's a constitutional provision similar to property tax, where municipalities can also opt not to levy property rates. Not that we will be that lucky. But when a municipality opts to levy development charges, there's flexibility both in terms, and I want to specifically relate it back to smaller developers. There's firstly provisions for the repayment periods, and Betweni will deal with a bit more detail in that. Then there's total flexibility. If you look at the clauses dealing with rebates and also exemptions, that is also under the control of municipalities, where either rebates can be given to smaller developments or upcoming developers, where they can either be, that is the choice of the municipality, to exclude them completely or to lower their development charges. And then there's also flexible repayment periods that Mtweni will deal in with more detail. With regard to and I'm just trying to see that, so it's definitely not a one-size-fits-all approach. The bill was written with the whole idea to create that flexibility with substantial choices. But the bill was also crafted to put in place transparency. So a developer also, when they pay development charges, they do want to know that the money is used for the correct purposes. So what the bill is trying to do is really to create a balance between the interest of a developer and the interest of a municipality, and try to make it a win-win situation for both of them. Then with regard to the municipal engineering services versus just using engineering services, when we go through the presentation, we will touch on that one. But the main reason why that has been done is to create complementarity between the legislation, the Municipal Fiscal Powers and Functions Act, as will be amended hopefully, and then SPLUMA, so that we don't use different types of definitions throughout the legislation. And maybe what is quite important to say here is that although it's only the City of Cape Town that came to the committee, we got substantial inputs from municipalities when we did our public consultation process. And what is quite interesting, we really had quite a difficult time. And in certain cases, we even had individual sessions with municipalities because municipalities contradicted each other. In certain cases, a municipality will push for something where another municipality will do exactly the opposite. So we took quite a lot of time during the public consultations to work through the inputs received and really to make sense. So we did in certain cases needed to make a balancing act on really what is best for the system. So it's definitely not just the City of Cape Town that gave inputs. We got substantial inputs from City of Joburg, substantial inputs from the City of Tshwane, just to give two examples. As Advocate van Schoor indicated, the two changes that's needed to the Municipal Fiscal Powers and Functions Amendment Bill, we did not present those two amendments to the National Assembly. The reason why we did not is not that we did not want to, but we unfortunately picked up those technical corrections that's needed after we presented to the National Assembly. And that is the reason why our Minister wrote to the chairperson of the Select Committee to ask that these be considered. So, of course, these will need to be resubmitted to the National Assembly to consider as well. Then with regard to the engineering sector, again, the similar issue was mentioned by Honorable Karim, that that we really need to protect the emerging sector. So if I can ask also just to add, or Mtweni just to add exactly how the payment schedule works and how it protects smaller developers. Mtweni, over to you.
Good afternoon. Still morning, Chair and colleagues. So, I'll start with the questions around the micro developers, especially the issue of allowing development charges to be paid as an upfront charge. So, although we are saying that development charges should be paid as an upfront charge, we've also made a provision in our bill to say that it can also be paid in tranches. And we did this given that we're noting the fact that other developments are being undertaken in various phases. So it will cost a lot of money for developers to be able to pay upfront for the whole phases of the project. So we are allowing them to pay development charges in tranches. And also that if that is the way they intend to pay development charges, then they need to enter into a payment schedule. So on the payment schedule, they will indicate when each phase will be starting and how much they will pay for each phase. But just to ensure that developments or projects do not get blocked, because currently what is happening is that if there is no bulk in place, you find that a lot of projects are being blocked or they cannot even continue anymore because there is no bulk. So we want developers to pay upfront so that once they start developing, they know that they will have the necessary bulk to be able to undertake their actual development. And there was also a question around, I will leave the one for Spluma, why we regulate development charges through Spluma, because Wendy, you have answered that question quite substantially. So all the points that I have written down, you noted them. But we are also providing or made provision in the bill that municipalities may grant exemptions and rebates to developers. And we put this provision in also taking into consideration the small scale developers, given that we know that some of them are just starting out and we do not want to crowd them out of the system. So we are allowing municipalities to grant them rebates or even grant them exemptions, but they need to comply with the set criteria that would have been set out in the DC policies by the municipalities. And there is another question around whether we had consulted with the Department of Human Settlements. And we did consult with the Department of Human Settlements, and they welcomed the bill and indicated their support, but they only had an issue around contributing towards the development charges, because they are of the view that their grants, both the ISDG and the USDG, has made a provision for funding bulk infrastructure. But we've indicated that although their grants do make provision to provide for bulk, there might be instances where you find that the 30% that they are earmarking towards the provision of bulk might not be enough to provide the required infrastructure that they want. Then they would need to top up, unless if the municipality decides to grant them an exemption or a rebate. And there was another issue around the internal engineering services as to what would be the impact if we refer to municipal engineering services instead of internal engineering services. So here, I just want to indicate that in terms of the definition that has been provided for in Spluma of the internal engineering services, they indicate there that these internal engineering services can either be owned and operated by either a municipality or a private sector. So in most instances, especially in the estate kind of developments, you find that the internal engineering services are owned and operated by the private sector. But when the developments are taking place, that is why we are saying that they need to enter into an engineering services agreement, because in that engineering services agreement, they will also need to specify that once the infrastructure has been completed, then who will be responsible for that infrastructure in terms of owning it and also operating it. But they have to ensure that it complies with the norms and standards that have been set out in the DC policies by the municipalities. Yeah, I think I've answered the remaining questions. Thanks, Wendy. Thanks, Chair.
Wendy?
Thanks, Chair. If we can then slide the slide presentation, and we can take you through the remaining issues that we picked up, and present on that we have not covered yet.
Okay. Can I just suggest that first we just ask anybody who wants to come back immediately? I don't see any hands up. All right, let's go to you. Now, we're not going to, Dennis wants to say something quickly.
Yes, Chair. You've got to give us a chance to put our hands up, eh? Thank you, Chair.
Yes,
so,
okay.
So, yeah, I do want to say that I found some of those comments to be fairly contradictory, and I'd like to just interrogate specifically the issue from Ms. Mpanya about tranches, and the ability of municipalities to levy the charges in tranches. Now, if one looks at page 5 of the bill, it's headed, page 5, chapter 3A, development charges, 9A. You scroll down about halfway down the page, you get to subsection number 5. And it says, unless otherwise provided for in the conditions of approval of a land development, an applicant must pay the full amount of a development charge before developing or utilizing the land following an approval by, and it gives you the details. Now, that to me indicates that tranches, specifically, unless otherwise provided for in the conditions of approval. So you'd need to apply for those tranches right up front, and you'd need to really know what you're doing. I think that is probably not a very fair way of looking at it, by saying, oh, we allow for tranches. I don't believe that you do, in terms of that paragraph. So yeah, there was also an implication from Ms. Fanu about there was an implication that there'd be ring fencing of the funds. She said, the funds would be used for the right purposes. There's nowhere in this bill, as far as I can see, and I'd love you to draw my attention to the point where it says that there will be ring fencing of these funds, and bulk contributions will only be used for bulk services. And then, of course, the big key issue that was that was mentioned, I'm not sure who did it, but it said, the comment was made, municipalities contradicted each other. And I think that is exactly the point that I've been trying to make. Different municipalities have different needs based on their different circumstances and the ruling circumstances at the time. To bring a bill in that forces everyone in a one-size-fits-all approach is not constructive, and it's not going to work for small municipalities specifically, where they are not able to draw up complex bylaws in terms of this act, complex bylaws to deal with all of the different situations that are going to come into play. Chair, I have massive reservations on this bill, and I think that the fact that municipalities kept on contradicting each other just underlines exactly what I've been saying today. But thank you. Let's hear the rest of the presentation. Thank you.
Yeah, but they also have to respond to you. So I think it's better to respond now, because there's specific questions flowing from what they've said. Otherwise, they'll get lost. Right, go for it, please, Treasury. Unless you don't want that, Mr. Ryder. Dennis, do you want to reply immediately or not?
No, that's great. Sorry, I thought you were talking to them. Yeah, I'm happy either way, Chair.
Oh, I thought you were just making the point that you're going to count to your chief whip that you did make all these points. Okay, fine. Okay, just neatly. Wendy, go for it, please. There's some good questions there, amazingly. I don't know. He's having a good day today, this chap. Sorry, I have to say the member to you. The member is having a good day and making good points. Surprisingly, I think he got up on the wrong side of the bed. But you go for it, Wendy. That's not your issue. That's between me.
Thank you very much for the opportunity. With regard to the tranches, I'll ask Matweni to come in there. Then with regard to ring fencing in the bill, it's not part of the bill. If you read through the sections in the bill, you will see there's no reference to accounting. The whole idea is to include the budgeting for development charges as part of the Municipal Standard Charts of Account, or MSCOA, that there's transparency there. So that is still work in progress. And more guidance will be given through that, through the regulations and the guidelines. But it is really, the whole idea is to make it easy for municipalities to comply, not to make it an over and above reporting system, but to make it part of the existing system. Then why did municipalities make contradictory remarks? We did not get that many remarks from the smaller municipalities. It's really the larger municipalities that made remarks. And some of the reasons, they actually wanted additional clauses added. And the reason why they wanted additional clauses added is that we redesign the system to be in line with what they're currently doing. So the issue of flexibility is definitely an issue. So, and some of the processes that's in place in certain municipalities are not in place in others. So it was to add additional provisions, and a lot of those cases, when something is added, there's a may in certain cases. I can ask also Matweni to give some examples where some municipalities wanted specific issues added to cater for the existing systems and how we dealt with that. So Matweni, over to you.
Thanks, Wendy. So I will start with the issue of tranches. So I forgot the colleague that I have asked the question, Mr. Ryder. Yeah. So you've drawn us to section 9A, subsection 5 of the bill, where it says unless otherwise provided for in the conditions of approval. So we put that specific provision there, the unless otherwise provided for in the conditions of approval, and we're linking it to section 53 of SPLUMA, because that section in SPLUMA, it's saying that the developers or the applicant, you cannot allow them to register a property unless they have fully complied with all the provisions of the approval. So if now when we are saying that unless otherwise provided for in the conditions of approval, so they can either in the conditions of approval indicate that you're going to be paying development charges upfront, the whole amount, or you're going to paying it in tranches. And then, or they might say, once you have completed the development, especially when infrastructure already exists, then we will check in the conditions of approval that you have complied with all the conditions that we have set out for you to comply with before we can allow you to transfer or sell your properties. And then with regard to the issue of ring-fencing, you asked that we indicate in the bill where we are talking about the ring-fencing. Although we are not specifically saying ring-fencing, but in section 9A3A in the bill, we're indicating that development charges can only be used for the purpose for which it has been collected for, and that is for the provision of capital infrastructure assets. So we take that as ring-fencing because they can only use it for that specific purpose. Then Wendy, your last question, I didn't quite get what the question was there. Maybe you can just repeat it for me.
Thanks, Matweni. I asked you that when we did our public consultations, we received a lot of submissions from metros in particular, where they wanted different things added, and how we dealt with it to ensure that we've still got the flexibility in the system. Thanks.
Okay. Thanks for the clarity, Wendy. Yes, so the ones that I can recall from the top of my head was around the issue of using a developer in our bill. So they were saying that we cannot use the word developer. The other municipality were saying we should use a landowner. But then after the public consultation process, other municipalities came and they were saying they do not agree with the word developer, they do not agree with the landowner, we should rather use the word applicant. And we agreed as National Treasury, after consultation with other stakeholders, that the appropriate word to be used is applicant. And that is the terminology that has been used in Spluma, and it covers the landowner. It even covers instances where someone is acting as an agent of the landowner. So we thought it was broad enough to cover the person that will be that development charges will be pinned on to be the person that will be liable for the payment of development charges. And then there was another issue around the accounting issues, where other municipalities were saying that we needed to provide more clarity in terms of how they are supposed to be accounting and reporting for development charges. And there were other municipalities which said that we needed to take out the whole accounting issues in the bill. And we ended up saying that we will take it out of the bill, but then we will provide guidance or circulars in terms of how they're supposed to be accounting or reporting on development charges. Thanks, Chair. Thanks, Wendy.
Thank you. Just one more point to add in terms of the tranches and the once-off payment is that we need to read section 9B4 together with section 9A5 that deals with the two issues. So those two sections just need to be read together. And then, Honourable Rider, just our apologies. It's MM's first time to present to the committee, so she unfortunately referred to it as Mr. Thanks.
That's no problem. You can call me Dennis as well.
Yeah, he's just saying that because he's desperate for votes, okay? And they need to be desperate given their ambitions, but that's not neither here nor there. Firstly, yeah, I think it's got a good presentation by her anyway, given that she's new and quite young. But I wanted to make a few points. Firstly, I mean, I don't agree with everything Dennis says, but I agree with the thrust of what he's saying. In other words, you know, the answers your team is giving is logical. It's technical. How practical it is, how it relates to what's happening on the ground is very debatable. So, for example, you will say, well, we have it in the bill that they can only use the money for that purpose. But it's now how many years later, since 1996, this new model, and we know that in many municipalities, including metros, things like that don't happen, as you yourself constantly harp on about. You have no capacity, neither has the province, to monitor that you do spend the money for the reasons set out in the legislation. How many of them in the municipal officialdom or staff or managers or whatever, or their MMCs responsible, will even know that? A matter of tranches, I'm not sure really. I hear what you say, but whether the municipalities which are smaller have the capacity to do that. Thirdly, on the matter of contradictions, the way I see it, this is inevitable, really. I don't think that's the big issue. We'll always have differences of views depending on the type of municipality you are, and so on. Your income, your source of income, your budget, etc. On the matter of a need for diversity, even two metros are not the same. Dennis is preaching to the converted when it comes to me. When I played another role, I was responsible for processing policy issues with the minister, and legislation was my area. And that was a big issue. It's been an issue discussed in the ANC workshops on local government and cooperative governance. I think there are resolutions even in national conferences around the need to look at this. Because eThekwini is a very different situation, say, to Tshwane. Tshwane is quite different to Cape Town, etc. And even all the local municipalities, they're far from the same. So Dennis, there you are right. But there are huge problems about it. We can't discuss it here. As I recall it, Selga was very unhappy, well, most of them were at the time. And there are some good points. I don't recall all of them, but it is an issue that we need to come back to, because to also manage a diversification of locals and what powers they exercise and so on is not easy. We then found a loophole by saying, with locals, it's easier because you have a district model. So if the district, in some cases, is stronger and the local is weaker, you can share the powers and functions well within the framework of the legislation. So that's a complex area, Dennis. I don't think you should give up on it. I still hold by that view, as do, I think, more people now than, say, 10 years ago. But it's a matter we can't resolve here. You're right. He's right, actually. Then there's the issue of your capacity, Treasury. You know, the more you do these things, which I think, unlike Dennis, are necessary, the more you have to ask yourself, do you have the capacity? Do you have the institutional memory to know why we opted for these powers and functions? Remember, you are not COPTA. The issues are not simply financial. Fundamentally, they're about governance. Fundamentally, they're about the parties that govern this country and the municipalities. And we said to your chairperson at the time that, you know what, don't try to solve issues through the Municipal Finance Management Act by thinking that you can control municipalities through wielding all this power over funds. Even then, Dennis, some of us argued from the, what is it called, the Provincial and Local Government Committee, that we had problems with some of the things being put in the original MFMA. But anyway, we are where we are. So on that one, Dennis, I don't know where we can take it, but you're right. I think in our report, Esther, you should say something about the committee once again. I don't know if we've raised it, but it's been raised in Parliament by the NA Committee in Local Government years ago. And the executive took it, I think, when Lechisa Senodi was the chair of local government, and said, look, we're looking into these things. So we must find the wording there that says something like this. The committee expresses its concern about the capacity of different municipalities, the needs and capacity of different municipalities to implement this, and raises once again in this parliament, because we didn't raise it, the parliament has raised it, the need for the executive to review and allow review the powers and functions and allow for diversity of the exercise of these, whether it's A, B, or C municipality or local district or metro, something like that, in the next term of parliament, after the fullest consultation with all stakeholders, something like that. I also think we should say, unless you disagree, the committee expresses, please, can those who do these reports, please note what we are saying and accurately cover it. There's recordings, please include, make that available, so we don't have a situation where a lot of work has to be done before the report is brought here, please. So the other issue is, shouldn't we say that we can always pick up on the themes that are emerging? The committee expresses its concern about the capacity of municipalities to implement aspects of this bill. We're also raised the issue or concern whether Treasury and the provincial treasuries will have the capacity to monitor the effective implementation of this bill. We're also concerned, I think, about whether there is a capacity in particular to monitor that the money that is drawn from development is used for that, the fees for the purposes set out in the bill, and the need for consideration of sanctions by Treasury. You have enormous power in withholding money and so on. You've got a lot of experiences of conditional grants not being used for the way they are. But all said, I still think this is a very good bill. In my view, it's long overdue. Many of the issues you're raising have been percolating since when? The RUDF times. And the Spluma bill was processed, I think, by Trevor Manuel in the presidency, if I'm right. I can't recall, together with land affairs. I've forgotten now. But these issues are not new to some of us who are older here. Some of the issues are new, and you've taken the debate, Treasury, and the bill far further than where we were, understandably. So I think it's a good bill. Anyway, I think we can move into the next stage now, which is you giving your responses, specific responses now. You've covered some of it, so don't cover the same ground. The reason we had to follow this slightly roundabout procedure is because these are unusual submissions in a written form that have to be taken very seriously. As far as the Free Market Foundation goes, they're predictably saying what they always say. That's their right. And the majority has a right to disagree. But on the constitutional issues, there's neither agreement or disagreement. It's not a policy issue. That the courts must decide. Either they or whoever wants to go to court should go to court. That's their right. And it might help Parliament to clarify some of these issues as well, because I think, given the parlous state of municipalities, it's likely that here and there, without being overly intrusive or unconstitutional, I think the national government would and should be treading into areas they haven't, as far as local government is concerned, without obviously undermining the Constitution. And it's interesting that SELGA, which fiercely defends its terrain and preserve, and for those who might think otherwise, it's not like the ANC is as united as it used to be. Over time, people have developed fiefdoms, it's clear, within the ANC alone. So, whereas previously they might have been more conciliatory towards a national position of the ANC, now they're not necessarily so. But interestingly, SELGA hasn't come to us. This is perhaps more their terrain, more their house than the NA's. They'll get greater sympathy here, but they're not even here. So I think it's a good bill. I hear Dennis. Dennis is making very good points, actually, but it doesn't detract from the value of this bill. So I don't want to belabor the point, but I think now we should, unless Dennis has something to say immediately, we should pass on to the next phase, and of course he and others can come in thereafter. Thank you. Over then to you. Can we go through that table now and look at quickly your responses where you haven't covered them already? And don't read the whole point out. Just make the point in a nutshell and then say this is our response. Thank you. Where we haven't discussed that point. We usually have a mechanical formula in following how we do it, but today is slightly different because, there is legitimacy in what Cape Town is saying. And we have to agree on some of these amendments, whether Treasury wants them or not. They're making sense to us, presumably, as a committee. So it's our call, and we should do them and send the bill back.
Certainly. If we can then go to the first slide. We've already touched on this one and the use of the wording. So we can basically skip this slide. We've already dealt with it. Then with the next one, basically, we do agree that maybe there's a potential to improve the wording, although there's no contradiction, there's nothing wrong with the wording. We can, maybe the committee can consider that the current wording be changed to refer to both the municipality and the applicant must agree, rather than both, as it's currently worded, that it will just give more clarity on exactly what is intended. So that is something for the committee to consider. If we can then go to the
Can I
next slide.
suggest, before we go on, is there anybody who has a problem with this? At this stage, you see, I'll look at the bill, obviously. I'll have time between now and next Tuesday. But for now, it seems straightforward to me. No harm in clarifying. In any case, we're sending this bill back, right? So is there anybody objecting to this? Are we fine with this? So let's not go over the same points again. To me, when I first saw it, it made sense to me. I looked at the whole bill this morning as well. So I have a fresher sense now. And I think it's okay unless somebody has a problem. Maybe Frank wants to look at it and comment next week, but unless he comes back to me and says, hey, there's a problem here, then you can discuss it with your lawyers and sort it out before next Tuesday so we don't spend undue time on this. Okay, please go ahead. So we're agreeing on that. Ikululeko, you're noting it, please.
Thank you, Chairperson. Next slide, please. And if I can then hand over to Tweni, and then I'll take over again. Thanks.
Thanks, Wendy. Yeah, we've also touched on this one. It's around the use of applicant.
I think we've covered this.
Yes.
Yeah, unless there's something new, can we move on here?
No.
And you're right, actually. I agree with you. I'm not even sure why they wanted landowner, but that didn't make sense to me. But I didn't want to pursue it further because it's making sense what you have. Thank you very much. Unless somebody disagrees, just butt in, please, because the screen is difficult now to manage with this thing there. So please, there's no need to put your hand up. Just say chairperson or just say Eunice or whatever you want to say. Just intervene. Thank you.
Thank you, Chair. Then this one, they were just saying that they wanted us to remove the whole section 9F, which deals with the engineering service agreement from the bill, and then insert it into its pluma. So we say that this suggestion is not supported, given that the requirement to conclude an engineering service agreement is not a planning issue, but a legal issue, and any sphere of government can prescribe key matters to be regulated through an agreement. And then in this instance, the bill makes provision for a municipality and an applicant to conclude the engineering service agreement to regulate key matters that must be considered when concluding an agreement to give effect to Chapter 3A of the Municipal Fiscal Powers and Functions Act. Then another one there, it's not a big issue because they were just saying that
hang on. We're dealing now with this issue. Don't go on to another one unless it's linked directly.
It's linked to it.
Okay, fine.
Yes, it's also under
because
the
what we're
engineering
doing to save time is we're asking members their initial responses to the policy issues, right? And then they will consult with their parties and whatever. Next Tuesday, they will tell us what their positions are. So we don't want to go through it and then come back to each one. So if they're linked, let's go for it, and then we'll consider both, right? Go ahead.
Okay, thank you, Chair. Yes, they were just suggested that we remove subclause V from the bill because they are of the view that we are committing the city to make future repayments to developers, and this might not be in line with their budget process and budget provisions. So they've incorrectly referred to this subclause V because it does not refer to repayments, but instead it refers to the engineering and other standards to which the installed internal engineering services or external engineering services must conform.
But why would they make this mistake? Can you clarify? I mean, those people are technical experts. Why would they get it wrong? Unless your drafting there needs greater clarity.
No. So where we are talking about the repayments, it's in the, okay, I don't remember the exact section, but then it's where we are saying that the applicant may install infrastructure on behalf of the municipality. And then if they install infrastructure of a greater capacity than what their land development requires, then they must make the repayments.
Yeah, but I don't understand why they misunderstood it. Okay, we must look at that clause. Frank, can you have a look at that clause, please, man, and see that the wording is as clear as it should be? And why is it that they raised this concern? So can I hand over to Frank to sort that out by next Tuesday? Will you come in and let us know? If you can't make next Tuesday for our meeting, and I hope you can, then you can just send us a written thing to say you agree with this response from Treasury, or you don't, and then suggest some wording to clarify their concern. Okay, all right. But you guys, as Treasury, can also look at it. Okay. I thought somebody wanted to say something. Anybody want to say anything?
No, Chair, that's just me. I just want to recognize the task. Thank you, Chair. I've got it. Thanks.
Yeah. You know why? Because I'm a bit concerned. I mean, they're also experts in their own field. And, I haven't got now the means to I mean, I have the bill on the screen, but to go through it, we're not finalizing things, they're tentative responses. So for now, we will keep this in abeyance. Let Frank come back on this one, the related ones. Thanks. Next, please.
Thanks, Chair. Next slide, please. Thank you. Then on this one, Chair, it's relating to the provision of external engineering services by landowner. So the city was just saying that this clause would in practice commit the city's budget prioritizing in areas which are not necessarily a priority in terms of the IDP. So we are of the view that their view is not correct, given that Section 9G comes to play in instances where the municipalities does not have the funding or capital or capacity to install the required infrastructure, and then agrees with the applicant that the applicant will install this infrastructure on its behalf. So it's basically what I wanted to indicate in the previous slide. So maybe they should have referred to Section 9G instead of the section that they referred to that relates to the engineering services agreement. But they further proposed or suggest that subsection 4 be amended as follows, by indicating that the municipality may reimburse or offset the amount in excess of the development charge, provided that it forms part of the municipality's master planning and capital budget prioritization. So here we just wanted to provide more clarity that the municipality is only expected to reimburse the applicant if the applicant has agreed with if the municipality has agreed with the applicant that the applicant installs infrastructure of a greater capacity than what his or her actual development requires. Then in this instance, the municipality has no choice but to make the necessary budgetary provisions to reimburse the applicant the excess amount, unless if the applicant waives his or her claim. Next slide, please.
Yeah, but can we just pause there at 9G? Are you continuing with 9G?
No.
Okay, you remember we're looking at each just to get the initial responses on your response to the public submissions. Right, anybody wants to raise anything here? When I mentioned Frank, I also mean the staff, apart from Frank, attached to the committee specifically. They need to look at these issues also and guide the committee on not whether we agree or disagree, whether the drafting in the bill doesn't create ambiguity and provides enough clarity. So that's the whole staff must look at these things, and we need reports from the content advisor, the secretary, and the research advisor. And then on the legal drafting side, Frank is doing his own thing for that one particular one. Okay, can we go on then? For now, there's no, if there's any hand that comes up, you just alert me, or they can just butt in, so to speak, or just come in, All right, go ahead, please.
Okay, thank you, Chair. Next slide, please. Sorry. Then here, the city is of the view that the bill does not cater for scenarios where an applicant is responsible for the installation of bulk engineering service if the land development requires the installation of the bulk engineering service other than in accordance with the applicable service master plan or capital budget of the city, if the city in the conditions of approval requires the applicant to perform the installation. So here we're just saying that firstly, it must be noted that the provision of bulk engineering service is the responsibility of the municipality and not the responsibility of the applicant. However, the municipality may require that the applicant contribute towards the cost of providing this bulk engineering service to service his or her land development, or agree with the applicant to install the required bulk engineering service on behalf of the municipality instead of paying development charges. This means that the municipality can only levy development charges for providing bulk engineering services, which it is constitutionally mandated to provide.
Any comments on this? Nope. So for now, it's okay.
Yeah, sorry, comment from me just to say that, look, that's a very clinical approach of how things happen. And in an ideal world, I'm sure it's correct. But in South Africa, I don't think it is always.
Yeah, no, I mean, that's a generic theme I've been making. I agree with him, I have to tell you. Look, in this committee, we judge what people say on their merits. They may not believe it, but the opposition parties, I don't care where they come from. If they're making a good point, the majority party must agree. You know, we can't be completely ideologically driven on everything simply because somebody's from another party. That's not the way it works under mine. That's not the way I understand my role as a chair, nor should it be that of the majority party. And frankly, as I've repeatedly said, although people might say, look at him, rich of him to say it, there is no need to be so adversarial in the NCOP. We are concerned about the issues about the provinces that we come from, the municipalities we come from, and so on, in a way that's different from the NA, which is more, let's say, party political driven. So I think, Janice, the point you're making is what's worrying me. Also, it's a generic point, not just about this. That's why I'm saying our report should be strong on this. And the incoming committee needs to monitor all these things and check on progress and call in Selga and the provincial treasury and the National Treasury and see where things are going. Okay, can we go on, please? Free Market Foundation.
Thank you, Chair. I'll hand over to
Don't go
Sandra.
through the whole thing. Just tell us your replies to each of these things. You've been through it earlier, yeah. Don't read it. There's no need, my friend. I know you mean well, but we've read it this morning in my case, and so on. So please, just give us the responses. Just make the point, meaning this is the point. Summary of comments from 9 to 4. And then repeat, your response, please.
Chairperson, we've dealt with this in quite a bit of detail this morning.
Yes.
So it's got to do largely with the constitutionality and the tagging.
Yeah,
so
let's move on. There's no issue here. Well, there are issues, but that's a court to decide.
So we finished our presentation.
I thought Frank's reply was very good, actually. Frank, I must say, you sort of moved me a bit towards agreement with you. Not but quite a bit, actually. All right. You see, we do listen, Frank. All right. So there we are. Now, I don't know what else you want to do today. I'm cool. I think it is better that we give people a week and then go through the bill. When we come back next Tuesday, initially, are there any new things? And then we look at it clause by clause, and we ask staff to prepare a report in the meanwhile, and we can also vote on the report. Just remind me, Nkululeko, next week is the last week of Parliament? Yeah, so we can't vote on it next week, eh? All right, doesn't matter. It's something that came to us very late, so, the public procurement bill is on that side. That'll be a very contentious bill. So, I think National Assembly Committee will be under pressure because we're reaching the end of this term to bring the bills to us, as Treasury will be to deliver it to Parliament in the first instance. So can we leave things till next Tuesday? And can we have a draft report ready by Friday from the staff? And can the staff and the legal services unit deal with the respective issues they're dealing with? Is there anything else, colleagues? Nope. Friday's meeting gets called off because we took it. There'll be public hearings today. And as it's turned out, and then Friday will be replied. There's no oral submission. I'm not sure why Cape Town didn't come. Maybe they feel that we won't listen to them. But it's not true, actually. But anyway, that's people's right. Okay, thank you very much. See you then. Bye.